Good morning, Dan and Amy. And before we get to the Chauvin trial, I did just want to make mention of these anti-riot laws that were passed in Florida. Governor DeSantis standing with law enforcement at a press conference explaining the law to the press. And
you can't love him anymore. And then he goes and does this.
Polk County Sheriff Grady Judd had this to say. Now you have to listen to what Grady Judd said and imagine the pictures he's holding up. He's explaining to the press what the difference is between a riot and a peaceful protest. And he has a picture on the one hand of a building being burnt down and a picture on the other hand of a bunch of people in the street with banners and stuff marching peacefully.
Peaceful protest, we encourage, and more riot. We can tell the difference. And I'll guarantee you that you'll be able to tell the difference if you come here and riot. If you come here and protest peacefully, we encourage that.
I love them.
Seems pretty straightforward. It's something that seems to escape the understanding of the press corps, as we saw from all of these ridiculous episodes of people, reporters, CNN and MSNBC standing in front of burning buildings talking about mostly peaceful protesters. All right, on to the Chauvin trial. It's gone to the jury, as we know. What, based on the evidence, should the verdict be? For help in discerning that, we're pleased to be joined again by our friend George Parry, who's a federal and state prosecutor out of Philadelphia and also a contributor at knowledgeisgood.net. George, thanks for joining us again. Appreciate it.
Glad to be with you.
So give us your assessment of the evidence that was presented by both sides and how you think this should shake out versus how it might.
Well, the way it should shake out is that the defendant, Derek Chauvin, should be acquitted on all charges. What's going to happen is anybody's guess. I gave up a long time ago trying to predict what a jury is going to do. But based on all of the factors, my sense is that there will be a conviction, most likely for manslaughter, possibly for even higher charges. And that's simply because the case never should have been tried in Hennepin County. It's a war zone. Everybody on that jury knows that if they vote the so-called wrong way, that is for acquittal, then there's going to be rioting and violence. And frankly, if I was on that jury, I would be fearing for my own personal safety if I were to vote for acquittal. So the prosecution, even though I thought that their expert lineup was underwhelming, to say the least, I think the prosecution has those major factors working for it, with jury intimidation and the fact that jury is going to have to take into account not only what will happen in Minneapolis, but across the country in terms of rioting.
It seems to me that that's something that the defense attorney should have spoken to, because it's in the back of your mind, and it seems to me that there needed to be a message that's and I'm not necessarily agreeing with it that he should be acquitted. Actually, I don't agree with you on that, but we'll get to that. But on this matter of what will be the public's reaction, defense attorneys, it seems to me, should have said that social justice and justice are incompatible. Look, there could be unrest that celebrating the verdict, celebrating whatever verdict you reach. There could be unrest protesting whatever verdict you reach. You can't let that factor into your decision. You have to make a decision based on the merits.
Well, yeah, but understand that what is being said in that courtroom, those are excellent. That's an excellent point. But what's actually being said in the courtroom is really secondary to the outcome in this case. Look, when the trial started, the city of Minneapolis settled with the George Floyd family for $27 million. The jury's aware of that.
Yeah.
Right.
And then there was actually rioting going on during the trial in Brooklyn Center Minnesota, which spilled over into Minneapolis. The courthouse is an armed camp, as are most of the precincts, police precincts and public buildings in Minneapolis. They've all been fortified. The city of Minneapolis announced that they were closing the schools this week in anticipation of the verdict coming in the case. All of these things were known to the jury. It wasn't like, these were things that could be kept from the jury, and the judge can tell the jury, ignore all this, concentrate on the evidence. He can say that until he's blue in the face, but it's all a legal fiction. The fact of the matter is, this is what's going on in Minneapolis. The jury is aware of it, and now we have Maxine Waters hitting town saying, oh, and by the way, if we don't get a murder conviction, then let it rip. So this is just, my contention is this case was lost at the time of jury selection, when they didn't have a change of venue out of Hennepin County. And if you look at what these jurors said in voir dire, the majority of them already started off hating Chauvin, and nothing happened during this trial that I could see that's going to change their preconceptions as to what he did and their feelings about him. So this is anything but a fair, impartial, and unintimidated jury.
Well, George Parry, I mean, the judge said yesterday that, if he is convicted, that there's a grounds for appeal because of what Maxine Waters said. Do you think that they would appeal on that measure?
Well, yeah, there are plenty of appeals they can take. I don't know if any of it will work. And if the judge really feels that way, he should have granted the mistrial motion. I mean, look, this judge seems to be a very reasonable guy, making all the right legal rulings and all of that. But when you boil it down, he had a chance to do the right thing right from the very beginning, and that is move this case out of Hennepin County. And if he really feels that what Maxine Waters said is potential reversible error, he should have gone ahead and granted the motion for mistrial. But he didn't. He's just kicking it upstairs. He's doing, it's a classic that you see here. A lot of judges may have serious doubts about the soundness of the case, but instead of granting a mistrial, they just want to see what the jury is going to do and then see if they're forced to actually rule on the motion. So this guy may be thinking, well, let's see what the jury does, and then you can always renew your motion for a mistrial after the jury comes in if you want. So that may be going on here, but my sense is he talks a good game, but he should have gotten this case out of Hennepin County, period.
With respect to the issues at bar, the jury's considering, it seems to me there's two. One is intent. Did Derek Chauvin intend to kill George Floyd? And then the other is whether or not he used excessive force. I think it's difficult to make out the intent claim because, well, among other things, the police officers call for an ambulance, so they sought to render aid. But in terms of the excessive force, I think that's pretty good. I think the prosecution did a pretty good job making that out. I think, as what you just alluded to, the experts that the defense brought forward to argue it was not excessive force were not compelling. And in fact, they sort of got cornered into saying some silly things. And it also seemed that Chauvin violated basic police procedure with restraining somebody who was having trouble breathing and then ultimately unconscious. So it seems to me they've got a pretty good case on the merits, setting aside all the politics, for a manslaughter conviction.
Well, you got a couple of things going here. Number one, Chauvin did not testify, which, in my experience, the jury always wants to hear from the defendant.
Right.
And if they want to establish what Chauvin's thinking was, why he did what he did, and why he did it for as long as he did, the best witness they could have had was Derek Chauvin. Now, I understand that the decision whether or not to put the defendant on the stand is a difficult one, and I'm certainly not criticizing defense counsel because I'm not privy to the information that he has. For example, I'm sure that he put Chauvin through any number of mock cross-examinations in private, and it may be that Chauvin didn't have any good answers, or he just would have been a terrible witness. So I'm not criticizing anybody here for not putting him on the stand, but the fact remains that if you don't have the defendant testify, the judge can instruct the jury all day long about the Fifth Amendment and how they can't draw any negative inferences based on the fact that the defendant didn't testify. But the fact remains, the jury wants to hear from the defendant, always. And in my experience, when you don't put the defendant on the stand, the case really turns into a slow guilty plea.
Well,
so that's the biggest problem.
What did you make of it when he took off his mask during his attorney's closing arguments so that the people could see his face?
Yeah, great.
Yeah, I remember that episode of Matlock too. I mean, that's
right. But
not,
did he follow proper police procedure by pinning him down on the ground like that with his knee?
Well, yeah.
Okay.
I mean, look, they can argue. Look, they should have put him in the recovery position and so forth and so on. The key issue, and I've been saying this from the beginning, the key issue isn't whether he followed correct police procedure. And defense counsel devoted way too much time to this issue yesterday, I thought. But the fact of the matter is, the whole case comes down to causation. And look, I'm not criticizing defense counsel. He was in the trenches slugging this thing out against a team of 17 lawyers that have 2 full floors of the Hennepin County Government Center and all the money in the world. And I mean, most of these lawyers were volunteers from big firms. So it was like a tag team wrestling where only one side gets to have a tag team. And I thought Eric Nelson showed a lot of courage taking this case on. But the key to the whole case was causation. And there was so much there that could have been used to knock that issue out of the park, and it wasn't used. Or at least it wasn't rammed home in the way that it should have been rammed home. And they wound up going down a lot of side streets that missed the mark as far as I was concerned in terms of the mechanism of death. There was plenty, and he made good use, that is, Nelson made good use of the Hennepin County medical examiner's testimony and what was in the autopsy report and the toxicology report. But there was even more effective use that could have been used with what the medical examiner had to say. And I thought that the testimony from the prosecution experts, to me, was underwhelming. And I agree with you about the defense experts. I was surprised at how poorly they came across, because they certainly had plenty to work with.
Well, here's the thing, too. If you're not going to put Chauvin on the stand, if you can't put him on the stand, like you said, you just don't think he'd hold up, then and it's a slow motion guilty plea, like you said, I completely agree, then why don't you plead him out? I mean, there are lesser included charges there. It seems to indicate that maybe you could have pled him out to a manslaughter charge and avoided all of this.
Well, there's a story floating around that at one time, this is going back months ago. Actually, it was back when William Barr was Attorney General. They tried to work out a deal where Chauvin would plead guilty to federal charges if the state charges would be dropped. And Attorney General Barr nixed that arrangement. He said, "You want to do a deal with us? You do a deal with us, but we're not going to be a party to doing away with the state charges." So there may be that there was a willingness to try and work something out with the state as opposed to the federal government back in the beginning, but that the state was saying, you want to plead, and plead open to everything, and we'll see what happens at sentencing.
Well, that you can't do. I get that. George Parry, former federal and state prosecutor out of Philadelphia. Also, he writes at knowledgeisgood.net. George, thanks as always for your insights. Appreciate it.
Very nice to be with you.
Thank you. And he joined us on our turnkey.pro answer line.
You're listening to Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560. The Answer.
The Lou Dobbs Financial Report is brought to you by Signature Bank, helping local businesses succeed. Visit signaturebank.bank for your commercial banking needs.
I'm Lou Dobbs. Coke sales rebound as vaccinations roll out. Foxconn and Wisconsin reach a new deal on a new facility. Those stories and more next.
If you drive a car, truck, SUV, or vehicle of any kind, you need Get Upside, the free gas app that pays you cash back for every gallon of gas you buy. That's right. With the free Get Upside gas app, you can get up to 25 cents a gallon cash back every time you buy gas. Nearly 3 million people have earned cash back with Get Upside just for buying gas.
I always use Get Upside. Some months I make $200 to $300.
I love getting money back for things I use every day. It's just free money for buying gas.
There's no catch. It's simple, and you get your cash back right away.
Download the free Get Upside app now in the App Store or Google Play to save up to 25 cents per gallon when you buy gas. Use promo code SEMI for a 25 cent per gallon bonus on your first tank. That's up to 50 cents per gallon on your next fill up. You can cash out anytime to PayPal or an e-gift card for Amazon and other brands. Earn cash back on gas on every fill up. Just download the free Get Upside app and use promo code SEMI for a 25 cent per gallon bonus on your first tank. That's code SEMI.
Coca-Cola says its sales are steadily improving as vaccination rates rise and restaurants and offices reopen. Coke says its global sales rose 5% in the January-March period, but